In this installment of LegallyBrief.com, former Attorney General Dick Thornburgh, who is currently counsel to the international law firm Kirkpatrick and Lockhart, Preston, Gates, and Ellis, will be talking about the attorney-client privilege.
The attorney-client privilege is the oldest evidentiary privilege in our legal system, with common law roots dating back to Elizabethan England. Our Supreme Court, in expanding the privilege to corporations and their lawyers, wrote in the 1981 Upjohn case that the privilege's purpose is to foster full and frank communication between attorneys and their clients, and thereby promote the broader public interest in the observance of law and administration of justice. The attorney-client privilege is critical to the operation of businesses for several reasons. First, because corporations cannot assert a Fifth Amendment right against self-incrimination. The privilege is the only means that companies have to protect their most confidential communications within their corporate structure. Second, the privilege's protections are essential in the creation, application, and management of an effective compliance program. America's legal and regulatory environment is profoundly complex, requiring lawyers' involvement at almost every turn. This leads me to my third and final argument in support of the attorney-client privilege, which is that lawyers today have assumed the role of corporate gatekeepers, and in order to fulfill their ethical obligations and to protect the public from bad business deals or harmful products, they must be fully informed and be able to speak candidly to clients. Over the past decade, federal government agency policies and practices have gradually eroded the attorney-client privilege as it applies to corporations. Through 4 separate memoranda issued by successive deputy attorneys general, the United States Department of Justice has pursued prosecutorial policies whereby a corporate target of a criminal investigation is viewed as cooperating if they waive their attorney-client privilege. Obtaining waivers, of course, provides a shortcut for prosecutors to develop their cases. The Securities and Exchange Commission and other regulatory agencies have advanced similar policies. Surveys have shown that a substantial majority of corporate counsel today feel that a culture of waiver now pervades white-collar law enforcement. The American Bar Association, the United States Chamber of Commerce, the American Civil Liberties Union, and of course the Washington Legal Foundation have expressed their deep concern with federal government authorities seeking to coerce waivers of the privilege. I share this concern, and I've expressed my thoughts on this to congressional committees which are examining the issue, as well as through a 2006 monograph I authored for WLF. It is encouraging that bipartisan support exists for this important business civil liberty. An Attorney-Client Privilege Protection Act passed the House of Representatives in 2007, but the Senate has yet to act on a similar bill sponsored by Senator Arlen Specter. I hope that business and public interest legal institutions continue to seek to educate policymakers and others on why the attorney-client privilege must be preserved. While the tide does seem to be turning against federal agency waiver policies, continued vigilance and advocacy will be essential.